from section 125 to 128. Uh, Whenever somebody says section 125, naturally it comes to our mind that it is all about the maintenance of wife. But it is not so. It is for the maintenance of wife, children, and even parents. Okay. So far as the maintenance of the wife is generally, we talk about the wife because it has been a controversial issue. Maintenance of wife has been a controversial issue. That's why section 125 is known by the maintenance of wife. So far as the maintenance of wife is concerned, do you find any provision relating to the maintenance of wife anywhere in any other law or act? Have you read family law still or not? In any semester, in which semester it is?
Sir,
Family
we
law.
are doing family law right now, and we also did. We had it in last semester, but since we had no classes, we don't know anything about last semester. But this semester we have family law too.
Okay.
Sir,
Yeah.
I think there's provisions under marriage acts, especially Hindu marriage act, for maintenance of wives.
Yeah, yeah. There is provision, rather are provisions in the Hindu Marriage Act, section 24 and 25. It provides about the maintenance of wife, and beside this, there is another act. Maintenance, it is in a separate act, Maintenance of Wife Act, 1956. What is the exact title of that act? Guardianship and Maintenance Act of 1956. There are also provisions for the maintenance of the wife. Why I am asking this to you? Because the question is, when there are already laws, provisions relating to the maintenance of the wife, why it has been given under CrPC? We should be critical about uh, every topic, that why it is given in the CrPC. Maintenance of wife is just a matter of is just a civil matter. It is a family matter. It is something about the dispute, civil dispute, a dispute between two private person. Why it has been brought under criminal procedure code? Because criminal procedure code is as such to deal with the criminal procedure. If there is any criminal substantive law, CrPC is for that law. CrPC explains the procedure of any relating to the punishment and other things of any substantive criminal law like IPC. But the maintenance is given in section 125. As it is in Hindu Marriage Act and another 1956 Act, and there is also the provision of maintenance almost in every personal law, like the Islamic law. There is also provision for maintenance, though it is up to the iddat period, but there is provision for the maintenance of wife. What all these laws are, the nature of all these laws is civil. There are the provision of maintenance, but they are given in the civil laws. And it is a considered view, it is an opinion that the decision of the civil dispute, any decision which is of a civil nature, it takes time in the court of law. And generally, it is considered that the criminal procedure, if something is under criminal procedure, it does not take as much time as civil matter take, reaching in the conclusion. However, it is altogether different thing. In our country, there is no as such the difference between civil cases and the criminal cases. Both type of cases take equal time, no issue. But theoretically, it is considered that the criminal matters are decided very fast in comparison to the civil matters. And the civil matters take a time. It was brought in the CrPC considering that it will become speedy, effective, and inexpensive. If the matter of maintenance is brought under CrPC, it will be an effective, inexpensive, and the speedy. Speedy is important. Speedy in the sense that whenever we put the maintenance in the criminal procedure code, it will not take as much time as it take in civil side, theoretically. And as I told you, the practically there is no as such difference. Okay, this was the one reason to bring it, because it is a question. It may be a question that it is just a matter of civil nature, is a matter of between two private person. It is a matter. It is a family matter. Not only the maintenance of the wife, even to the parents and the children. All these are family matters. Why it has been brought in the CrPC Criminal Procedure Code? So this was the one of the logic. And the second logic, second reason why it was brought in the CrPC, that is, it not very high, but to some extent, it provides the provision of punishment. Under Section 125, there is provision of punishment. But on the other hand, in all those laws, there may be a penalty in the form of fine. That is the different thing. But a person may not be sent to jail under all those laws. The second reason is this, to bring it in criminal procedure code, as it provides punishment. Punishment who is not paying the maintenance, or rather not following the order of court related to the maintenance. That is the reason it was brought under CrPC. Now let us come to section 125. Section 125 talks about that any person who has sufficient means is liable to maintain his wife, children, and it is very important which differentiate this maintenance of CrPC with other civil laws, that is, it also covered the illegitimate children. Under Hindu Marriage Act and all other family person laws or act, that maintenance is only confined to the legitimate children. But the maintenance under section 125 makes a scope wide. It also covered illegitimate children. Okay. Legitimate and illegitimate children who are minor. Generally. But in some cases, even the major children. Some cases means if the child is major but he is unable to maintain himself or herself due to any physical or mental abnormality, or for any other reason unable to maintain himself or herself, despite of being that he is a major, it is the liability to maintain one's children, even they are major. And the third category is the parents. And everything, maintenance of every category, including wife, children, parents, it is qualified by a condition if they are unable to maintain herself or himself. If they are able to maintain themselves, there is no question of maintenance. Now, if I ask you, does it include daughter, or it is just confined to the son? For example, in the matter of parents, as in the case of wife, obviously there is no other option. Only and only husband has to maintain. Does not include married daughter. Who is this? Yes, please come again. Your speaker may be on. You may talk. Okay. Anybody else? The daughter, according to you, the daughter is not entitled. Okay. Mic is not working. That's all. Okay. According to you, the daughter is not liable to maintain. In the case of husband, there is no controversy. But A very interesting thing is this. Not under section 125, but in the context of, suppose if we talk about the section 25 of Hindu Marriage Act, if I ask you, it is very much clear that the husband is liable to maintain his wife. Okay. But there is a situation that husband has not a sufficient means, but on the other hand, wife is very well off. She has so many banglas, so many cash in the bank, and so many property, etc., etc., etc. And the husband is not able to maintain even his daily bread. For example, it is very near to impossible that to have such a match. But just for the sake of example, if I ask you, is that wife is liable to maintain her husband or not? What would be your answer?
Yes, sir.
Are other agree with this answer? Yes. And it is altogether different thing than no controversy, or there are rare controversy like that, like this. Husband never goes to the court to file a case for his maintenance by his wife. It does not happen in practice, that is the different thing. But according to law, is he can claim maintenance from his wife. Okay. But the same thing, why I explain this thing, it is not the case with the section 125 of CrPC. Under section 125, it is clearly given who can claim maintenance from whom. That's all. Not beyond that. So for that, it is necessary, as somebody answered, with regard to the daughter. According to you, your daughter is not liable. Why daughter should not be liable? Suppose if there is a case where parents have only a daughter, they have no son. What would you say in that case? To remove this doubt, the very first line or very first two word of section 125 goes like this. It is section 125, order for maintenance of wives, children and parents. If any person having sufficient means neglects or refuses to maintain, if any person means it includes daughter. Daughter in the case of parents and children. If any person having sufficient means neglects or refuses to maintain his wife, unable to maintain herself, and maintenance of everybody is qualified by the unable to maintain herself or himself. Two, his legitimate or illegitimate minor child, whether married or not, unable to maintain itself. See, his legitimate or illegitimate child not being a married daughter who has attained majority, where such child is by reason of any physical or mental abnormality or injury unable to maintain itself. And the fourth one is father or mother unable to maintain himself or herself. It is the liability. Under section 125. Now the jurisdiction, in whose court the application for maintenance is filed. It is filed in the court of magistrate of first class. So we have read the jurisdiction as a jurisdiction. We must be clear about always in every case clear about the jurisdiction. In the court of a magistrate of the first class, it is given in clause 1. Now the next important question, how much or what is the amount? Up to 2001, it was fixed rupees 500 per month. But in 2001, there was an amendment and this 500 rupees 500 was deleted. Now under section 125, no amount is mentioned. It is left to the state. Each state may decide accordingly. Whatever state wants to fix the maximum amount of maintenance, maximum limit. Suppose maximum limit is 5,000, it is not necessary that the maintenance will always be 5,000. It is up to the court. Court may fix the 1,000 rupees per month or 2,000 rupees per month, etc., etc. But court cannot go beyond 5,000. Therefore, the maintenance amount is different, is varying from state to state. For example, in UP it is the 5,000, in MP 2,500, Maharashtra I think 1,500. Every state has the different amount of maintenance. Okay. It is also given in this clause. At such monthly rate as such magistrate thinks fit, and to pay the same to such person as the magistrate may from time to time direct. And there is one proviso. It is provided that the magistrate may order the father of a minor female child referred to in clause B to make such allowance until she attains her majority, if the magistrate is satisfied that the husband of such minor female child, if married, is not possessed of sufficient means. It goes a step ahead. In case the daughter is married, but in case if her husband has no sufficient means, it is not enough to say that we have married our daughter, now we have no liability. No, according to section 125, if her husband has no sufficient means, in that case, it is the liability of the parents to maintain their daughter. It's very important. Okay. And as I at the outset, I told you that this provision was brought under CrPC for to expedite or for speedy justice relating to the maintenance. But see the irony. In 2001, one proviso was added in section 125 and which talks about the interim maintenance and expenses. What does mean by interim maintenance and expenses? Till the decision of the court magistrate court under section 125, the magistrate may fix an interim maintenance to the wife, children, parents, etc. All the category. And court may order for expenses to give the expenses in that exercise. That exercise means the victim, the affected party is coming to the court and the filing the application before the court. Obviously, there is, there are, there must be some expenses. It is given in this proviso that expenses and the interim maintenance until the decision of this maintenance order, the court can order for maintenance. So what is the irony in this? That the object of this maintenance provision under CrPC is speedy justice. But even under section 125, the experience was like this. Yes, please. We again, what is just okay. Yes. Okay, okay. We are coming to that point. We are coming to that point. It is specifically given under section 127. We are coming. We are coming. We will cover all these points. Okay. So it is not better to answer me right now because when we discuss that section, all such doubts will be cleared. Okay. Uh, and it is very important. You have asked the right questions because we know about the jurisdiction. Jurisdiction is different. But the rules of jurisdictions have been widely deviated under section 125. And there is a logic for that. Okay. The general rules of jurisdictions are not applicable in the case of maintenance cases and not in the maintenance cases, even in other matrimonial cases. You will always find some exception, even under Hindu Marriage Act and other, wherever there is any matrimonial matter, you will find some deviation from the general rule of jurisdiction. Okay. Okay, let me come to there. What I was talking about? Uh, yes, interim maintenance. And in this amendment, it was made mandatory that the Interim maintenance and the expenses, the decision on the interim maintenance and the expenses will be given within 60 days, not more than that. What is the situation? Because the actual maintenance, the fixing of actual maintenance is taking time. Within 60 days, the code may fix an interim maintenance subject to final decision. Experience was like this, that even the maintenance cases, even under section 125, were being accumulated, and they were taking the time, huge accumulation of the cases under section 125, and we experienced the pendency, a lot of pendency, even in section 125, which was brought to give the immediate relief. Therefore, in 2001, these two provisos were added in section 125, and for this, for the purpose of section 125, it is very important, and explanation itself gives that to define the who is the minor and who is the wife. Minor you will find everywhere. The minor age is, it is given in the Indian Majority Act. With the same thing, it says that explanation. Minor means a person who, under the provisions of the Indian Majority Act, is deemed not to have attained his majority. He is a minor. Okay, because it remains a big controversy. Who is a minor and who is a major, particularly in criminal cases. Okay. And a lot of time is consumed if the is consumed on this point. Criminal trial could not be started because first it has to be decided whether at the time of the commission of the crime the accused was a minor and the major, and many a times the accused take the benefit of this, and you may have heard so many controversy regarding this. Next, explanation B. Definition of wife. Who is wife? Everybody knows. But in this explanation, there is a very peculiar definition of the wife. And if this peculiar definition is not brought, the purpose of the section 125 will not be solved. And you must have heard about the Shavano case. A very controversial case, Shavano case. What was the Shavano case? All controversy was regarding to the definition of wife. So wife means whosoever is married. But explanation B, section 125 says that even whosoever has been divorced and has not remarried, she is also wife. Wife is married. After some time, she is divorced. And suppose if she lives for next 70 years, 80 years, up to 80 years, she will remain wife under section 125. And that was the main controversy in Shavano case. What about widows who have attained majority? Yes, of course. No, widows. Yes, but not by the husband. Of course, they will not get the maintenance from the husband. They will get the maintenance from the husband, parents, husband property. If she remains in that very house after becoming widow, and if she goes her parents' house, those parents will have the liability to maintain her. Because your question is what about widows who have attained majority? Then, in case of wife, there is no question of uh, minority and majority. Minority majority is related to, or in the cases of children. According to your question, if that widow has not a sufficient means, the only things it will do. If she has no sufficient means, suppose if there is a widow, but her husband has left out so many property, so many cash, a huge cash, many property. Obviously, she cannot claim the maintenance from anybody. That's why I am repeating in time and again that every maintenance is qualified by that if she is not or he is not able to maintain herself or himself. So we have to keep this thing in our mind. That's why the maintenance case is decided by the magistrate. Because magistrate has to look into all these, all these things, right? Is that okay? Should we proceed?
Excuse me, sir.
Yeah.
So actually, what I meant to say is that, for example, if you said that if the husband doesn't have enough means,
Hmm.
then the parents incur the liability to maintain the woman. So in that case, if the widow doesn't have proper sufficient means that has been left to her by the husband, then she comes under the purview of parents. And in case of parents, the majority and minority clause also comes into play. Then will she get entitled to some maintenance from the parents in case she is
Yes, yes,
altogether?
yes, yes. She will get.
But sir, clause subsection C of 125 says that if the child is not a married daughter, then she can claim maintenance. Then doesn't that conflict?
So clause C.
125C says his
Ah,
illegitimate or
yes.
legitimate. Yeah.
His legitimate or illegitimate child not being a married daughter. You are talking about this, na?
Yes, sir.
Who has attained majority. Therefore, there is the provision, na? Again, the provision is given, na? There are three proviso. And in that proviso, it is made clear.
Okay, okay, sir. Yes, I get it.
Okay, got it.
Thank you.
We have just discussed those proviso. Should I go again to that
No, sir, I
proviso?
got it.
Okay. Uh, yes, so aspiration clause B says that wife includes a woman who has been divorced by or has obtained a divorce. Either she has been divorced or she herself has taken the divorce from her husband and has not remarried. But the only condition is she should not remarry. If she remarry, in that case, she is not entitled to claim maintenance from her husband. What happened in Shavano case? The Shavano, Madam Shavano had not remarried. Okay. I think time is